Welcome everybody to this March edition of the 3PB Family Law Brunch seminar series. It's a pleasure, as I've said, to see so many of you taking time out from your busy mornings, and thank you for doing that to come and join us. We've got, as ever, two speakers today. Gemma Chapman, a specialist family law barrister with our family team at 3PB. Her particular focus is on public law proceedings. And she's going to be talking to us on preserving the evidence, a public law update. Well, Legal 500 says that Gemma builds up a fantastic rapport with the clients and really gains their trust. They say she's got an ability to cut to the chase and deliver focused and pragmatic advice. So her talk promises to be engaging and informative, I'm sure. I'm going to start. My name's Hamish Dunlop. I'm a member of the financial remedy team at 3PB Buildings, and I too am hoping to deliver something of a retrospective to you over the course of the last year. I'm going to be talking to you about financial remedy claims in COVID and Brexit times, caught in a storm. Well, I think with no further ado, let's start with my lecture. I'm just going to load up my slides now, apologising to you in the format in which they arrive. Because you have the thumbnails to the left-hand side of the screen, but the main text, of course, is to the right. So this seminar is essentially a themed financial remedy update, as I indicated. It's really designed to review some, but not all, of the more important decisions in financial remedy cases over the course of the last year. And as the title suggests, the theme concentrates on the consequences of the current perfect storm caused by Britain's departure from the European Union in January 2020, and of course the effects of the subsequent COVID-19 pandemic. And it really focuses on two consequences of that storm: the effect on final orders, the loss in value of businesses, and with it the net wealth of the investors, reduction in liquidity to meet financial remedy claims. And secondly, it deals with delays in proceedings, litigants needing maintenance in the meantime, expert valuations becoming out of date, and so forth. And the selected authorities that I've got for you reveal how these issues are being managed at the higher court level. In fact, I have 5 cases from the High Court, 3 from the Court of Appeal, and a Supreme Court authority in the selection. And over the course of the next 25 minutes that I've got available before you're dazzled by Gemma's talk, I'm going to refer to them all for you, obviously some in less detail than others. But if I move too quickly, there's a separate handout. That, of course, deals with them in a little bit more detail. Well, in summary, the topics and cases we're going to be reviewing are as follows. 1, how to deal with making final orders where there's a temporary lack of liquidity in the pot, cases of Haskell and AW, which many of you may be fairly familiar with. The extent to which varying a final order is possible when the financial landscape changes dramatically, case of CB and EB, and also referred to in Akhmedova. Thirdly, how the court can deal with out-of-date expert valuations by the time of trial, in the case of Finch and Baker, a PODE report, a pension report. Fourthly, regulating occupation of the family home when there are delays in selling it, as occurred for 2.5 years in the case of Diwali. So sorry about that. And then I couldn't, of course, deal with the case, with this discussion without looking at Rattan and Kuwad, applications for maintenance pending suit. And then finally, we're going to conclude with the two recent bouts in the matrimonial epic that's been Villiers and Villiers. Well, as Julie Andrews said, let's start from the beginning. Haskell. Where there's been a dramatic fall in the value of assets, there's occasionally no immediate wealth in the pot to distribute, and the court, of course, must then look for ways to postpone the moment when the final award becomes payable, so as to provide an opportunity for the parties' finances to improve. 2 cases reported in the spring of last year, Haskell and AW and AH, suggested that postponing all or at least part of the distribution process might become a common theme. but in fact, there have been, in my view, no reported cases since then. Neither Haskell nor AW introduced to us any new jurisprudence. And it's revealing that in both the cases, the applicants, who were the wives, actively supported a deferment of the award. They were both represented by leading counsel. The impoverished husband respondents were in person. They turned up to court, metaphorically turned out their pockets and said, I have nothing. And so there was little dispute about the unusual approach that the court took. But the fact that 2 High Court judges have been prepared to postpone the day of reckoning might encourage others to do so, if that's something that we require the court to do in our case. And therefore, these are 2 quite useful authorities. And as it happens, they both provide different variants on that theme. So in Haskell, currently on screen, husband was a 53-year-old international businessman. Wife was a 39-year-old former Russian model. It was an 8-year marriage. The fall in value of the matrimonial assets, I suppose, is displayed by the figures on the screen. During the marriage, the husband's estate was worth, said to be $185 million US. By the time we got to the Form E in 2017, that pot had fallen to 44 million. And by the time of the trial, it was in deficit to the tune of 50 million. Well, Mr. Justice Mostyn accepted the parties' joint approach to the model of the order. That was a lump sum in 2 instalments, 2 years apart. He said the overall award, of course, is going to be addressed by wife's needs only. Despite the large sums involved in the marriage, there was no marital request at the time of trial in the light of the downturn, and so therefore no case for sharing. And therefore it was a needs case. Needs, he said, must reflect the past standard of living, the likely upturn in the husband's future standard of living. And it has to be said that he then went on to assess the wife's need at 6.2 million, which is what you get if you're a former Russian model. 1.65 million now, and the balance of it 2 years later. And the key was that he gave express permission to the husband to extend time for payment of that balancing sum if there'd been no improvement in his fortunes. Compare with that the case of AW. Facts easily stated, a rather more mature couple, 63-55 at trial, no children. The husband was worth £86 million just before the marriage in 2001. But by the middle of the marriage, he lost it all and was in bankruptcy. By trial, slightly recovered his position. He had 2 pensions, but there were no pension assets apart from some wine, which made their way into the judgment. But Mrs. Justice Roberts, trial judge, identified the latent potential of in total 5 of the husband's companies. And she decided to postpone then the day of reckoning in relation to wife's principal claims. She adjourned the lump sum and the property adjustment claims for 7 years. She made a pension sharing order in respect of one of the husband's pensions and directed that if the husband drew on the one that he was retaining, he must tell wife he was going to do so. And the court granted wife a nominal periodical payments order. Now, it has to be said that Mrs. Justice Roberts marked the unusual nature of the order that she was making by citing Mr. Justice Mostyn in Quan and Bray, and that quote's on the screen now. While generally capital claims should not be left indeterminately unresolved, she said, there were hard cases such as this where fairness and justice must prevail over the normal desirability of the finality of litigation. So we move from making final orders to varying final orders. The interesting case of CB and EB, another authority from Mr. Justice Mostyn. I find this a useful case because, predictably, it distills the current law on setting aside final orders into, well, a digestible 16-page judgment. Again, facts stated simply, parties in their 60s, 20-year marriage, 2 grown-up children. Husband was a successful property developer. Properties were worth £12 million at the trial in 2010, and Mrs. Justice Barron made orders which distributed some of those properties immediately, and then ordered for sale in relation to others with proceeds to be divided, of course, in a particular manner. But over the course of the next 10 years, the husband's retained properties sustained a dramatic loss. And the husband ended up with, he said, £1 million worth of assets, with the wife having 8.5. And he said that can't be fair. And he applied to vary the terms of the order. Well, let's remind ourselves about what the grounds are for varying orders. It really falls into two halves. There's the statutory right by virtue of Section 31 of the Matrimonial Causes Act, which lists a distinct and fairly limited list of orders that can be varied. They'll be familiar to us: maintenance pending suit, spousal PP's orders, and the varying of the timing and manner of lump sum payments by instalments. So you've got that sort of statutory collection under Section 31. Or you've got those that fall outside the Section 31 list, which include the more kind of conventional lump sum orders, property transfer orders, and so forth. However, if you're going to successfully obtain a variation of those outside the Section 31 type cases, that is your conventional lump sum property transfer orders, then you must prove one of the traditional grounds, as Mr. Justice Mostyn called them. What are the traditional grounds? Well, the answer is fraud or mistake, material non-disclosure, a barter event. Insofar as the order contains undertakings, you can vary the undertakings. And if the court remains executory, of course meaning taking effect on some future contingency. Well, the barter event, of course, is a new event invalidating the basis of the original order and has to occur very shortly after trial. And so, although, of course, the husband in this case said, well, there had been new events, he couldn't fit it into the barter category because these had occurred many years after the making of the order by Mrs. Justice Barron. So he made, you might think, something of a bold submission. He relied on amendments made in 2016 to the Family Procedure Rules, 9.9a. Now, for those of you who may remember, this amendment was designed to extract us, the legal community, from the quagmire of doubt about what procedure to bring if you wanted to challenge an order under the traditional grounds. Should we be appealing? Do you go back to the original judge? Do you bring new proceedings? And at the time, FPR 9.9a in 2016 really showed us the light, showed us the correct path. That's an application within existing proceedings by Part 18 to the original judge. But the husband said, oh no, that this rule is more than procedural. It marks a development in the substantive law. It marks a break from the traditional grounds, and the court, as a result of the rule, now has a wide discretion to set aside final orders where it's just to do so. And he said, no more just in my case, where the value of all my properties has tumbled so dramatically. And he also relied on the practice direction 13.5, which you also see on the slide. The grounds on which a financial order may be set aside are and will remain a matter for decisions by judges. The grounds include, and then there is the list, which essentially are the traditional grounds. But note the word include, not is exclusively limited to. Well, what did Mr. Justice Mostyn make of those submissions? The answer, with the greatest respect, is not very much. He dismissed the husband's application. He expressly agreed with the editors of the Financial Remedies Practice 2021, who had essentially predicted the point in their text and ruled it out. Of course, he was good enough to remind us that he was one of the editors of the Financial Remedies Practice 2021, so perhaps no surprises there. But he concluded his judgment by saying, in my judgment, the language of FPR PD 9A, para 13.5, is misleading. It should not be read literally. There is no lawful scope for imaginative judges to unearth yet further set-aside grounds. The available grounds are the traditional grounds, no more, no less. Now, in the course of his judgment, he recognised that Mrs. Justice Gwyneth Knowles, in a relatively recent case of Akhmedova, had come to a slightly different decision, you might think. She, when dealing with the force of 9.9a, said, whilst the categories of cases in which Rule 9.9a can be exercised are not closed and limited to the traditional grounds, the jurisdiction to set aside is to be exercised with great caution, etc. And she went on to expand on that. But the point is, of course, that she also seemed to have held the door open to expanding the grounds beyond those that are the traditional. So it may be that we've not seen the end of this particular debate. Well, we now turn from final orders to a series of more discrete problems raised by the current situation, and in particular in relation to case management. We start with Finch and Baker, the problem of valuations that are out of date for assets when the court comes to make its order. We know, of course, about the general rule on the valuation of assets at trial. The general rule is that assets are to be valued at the date of the final hearing, not least because Lord Hope told us that in Miller. Finch and Baker concerned the valuation of the wife's significant BBC pension. This was a case originally tried in Bristol by District Judge Watkins, appealed to the Circuit Judge, and then appealed again by wife to the Court of Appeal. And there were a number of grounds she was pursuing, but it was the treatment of that pension which gave Lord Justice Moylan cause for concern. And it was because at the time the Court of Appeal resolved the case, the PODE report, the Pension on Divorce Experts report, was 4 years old. And the effect of that is probably illustrated by the figures that you see now on the screen. So the PODE report valued the wife's pension at 1.9 million. Documents received by the Court of Appeal in 2021 reveal that by the time it finally came to be dealt with by the court, it was worth 2.7 million, so essentially 50% more. Just very briefly, as to the first instance proceedings, Judge Watkins gave to the husband a 48% pension share. On appeal to the circuit judge, that was reduced to 34%. And I think probably the key to it is this, that the circuit judge reached that view because he concluded that it would provide to the husband £22,000 a year of gross income, and that met his needs. Wife, after the circuit judge had given his judgment, then applied for an updated PODE report saying, well, by now, I think it was 2 years on by then, by now the original one's out of date. Of course, not surprisingly, the circuit judge refused that application, and the wife then appealed that, amongst other things, to the Court of Appeal. Well, the wife was unsuccessful. Lord Justice Moylan, who gave the leading judgment, was critical of the way that the wife had tried to apply for updating reports after the judgment of the circuit judge. And obviously that feature influenced the Court of Appeal quite considerably. But Lord Justice Moylan did have to deal with the point about the out-of-date valuation, because of course it arguably completely undermined the circuit judge's order. And this is why, because the circuit judge had ordered 34% on the basis that it would give husband 22,000 per annum to meet his needs. But that was based on the 2017 valuation of 1.9 million. By the time the Court of Appeal came to look at it, the pension plan was worth 50% more, and the husband was 4 years older. And the effect, of course, would have been that he'd be getting a much larger income. Well, Lord Justice Moylan thought about that and decided that irrespective of that, the appeal should be dismissed. Because he said, look, the judgment did in fact reach the desired outcome based on the evidence before the circuit judge, albeit a little out of date, and to that extent it was fair. He said if you update the pension evidence, you've got to update everything. And finally, he said, of course, in relation to pensions, there's always a delay between the valuation in the PODE report and the valuation of the pension at the date of implementation. But perhaps a more general application, he concluded with this rather helpful quote at the end of the judgment. He said, this is another example of the court's powers under the MCA 1973 being exercised in a broad, discretionary manner and not necessarily with the expectation of achieving mathematical precision. And of course, where we may, in the current problems, suffer out-of-date valuations, it's a very useful authority to have in the back pocket. And so we come to other consequences of delay for Mr. and Mrs. Dervali, this time in the selling of the family home. In giving judgment in the Court of Appeal in this case, Lady Justice King said that it turned on its facts, but she also described it as a cautionary tale. And in my view, it is a bit of a cautionary tale for those of us who frequently draft final orders and do so relying on the compendium of stand-in orders. It helpfully also provides a sort of modern review of the law concerning how to implement court orders, and in particular, of course, financial remedy final orders. The case concerned a 26-year marriage. Parties had 2 children in their early teens. They both lived with the wife in an expensive home in central London. Importantly, to understand this case, that property was owned by the husband, and husband alone. In the 2016 final order by consent, there was an order for sale, but wife continued to reside there on fairly familiar terms. She removed her home rights notices, she paid the outgoings while in occupation, but the order didn't provide an express right for her to live there. Of course, if we think about those compendium orders, they tend not to do that. Well, the property took 2.5 years to sell. And after 6 months, the rather cheeky Mr. Dervali went off to the county court, not the family court, you note, and sought possession of the property from the wife. On the basis, he said, that I'm the legal owner, and wife is a mere licensee once the marriage has concluded. And he said, if I can't have possession, I want occupational rent at £5,000 a week. And by the time we get to the Court of Appeal, then the arrears are £600,000. And remarkably, the county court judge granted him the relief he sought, ordered possession, treating Mrs. Dervali as a licensee. Not surprisingly, she successfully appealed to the Court of Appeal and to Mrs. Justice Arnold, who discharged the possession order. Husband was having none of that, and he went off to the Court of Appeal. Not surprisingly, the Court of Appeal dismissed the husband's appeal, but this is the analysis that Lady Justice King carried out. First of all, she considered what was the right approach to the issue. She said it's an approach not based on wife's entitlement to occupy a property. It's not a property right. It's given to her by virtue of the terms of the consent order. She reminded us that consent orders, of course, are not contracts per se, because they derive their authority from the approval of the terms by the court, not from the underlying agreement of the parties. But she did say that in interpreting orders by consent, contractual principles applied. And those contractual principles are derived, she said, from Lord Newburger's analysis in a case called Arnold. And they turn particularly on 6 criteria, which I won't detain you with now, say perhaps the most important, which is that you look at the overall purpose of the clause under scrutiny, in this case, the clause ordering sale, and you look at the order as a whole, you look at the contract as a whole. And she said, the court must also look at the approach to the meaning of a contract as defined by Lord Hoffman in a case called Chartbrook. That is, what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be using the language in the contract to mean. And she decided that, judging by those tests, the terms of this order strongly indicated that the parties' agreement had the effect that wife was entitled to live in the house until it was sold. And you may think, obviously so. She concluded by recommending that perhaps in excessive caution, parties should be more specific as to the precise terms under which it's drafted that one of the parties remains in occupation of a family home pending sale, obviously particularly if it's the other party who happens to own the property. Well, we're in the closing stages, ladies and gentlemen. I think it would not be right for me to give this lecture without, of course, referring to the case of Rattan and Kuwad. Mike George from 3PB has already given a detailed presentation on this case in last month's 3PB Brunch seminar, and so I don't propose to rehearse his authoritative analysis given in that seminar, but I've included it in today's talk because some might have missed Mike's lecture or might not be aware of this relatively important case. Important, in my view, because it's the first time in 10 years or so that the Court of Appeal has reviewed the law in relation to applications for maintenance pending suit, and therefore it's going to be useful to us. I hope the statutory provision of Section 22 is familiar to us. I'm not going to read it out, it's there on the screen. And just by way of a quick thumbnail of the principles we derive from the order. Again, Lord Justice Moylan giving the main judgment with which Aspin and McCurr, Lady Justices, agreed. An order for maintenance pending suit must be reasonable. That's synonymous with making an award that's fair. MPS orders are to meet immediate needs. The particular circumstances will determine the court's focus and degree of scrutiny that's required into those immediate needs. Put short, with high net worth cases, it may require more scrutiny, but a broad brush can be approached to your more run-of-the-mill cases. Immediate needs must recognise that some costs are not necessarily incurred weekly or monthly. Some are incurred less frequently, but that doesn't stop them being immediate needs. The key facts a court must look at are needs, resources, and the standard of living of the marriage. And finally, we learn from the judgment that you can include in a claim school fees on a maintenance pending suit application. And so, in conclusion, and I have to say something as a footnote perhaps, we look at the lamentable tale of Mr. and Mrs. Villiers, a long-running battle fought across the jurisdictions of England and Scotland, more bitterly, I suspect, than the Calcutta Cup. Mr. and Mrs. Villiers separated in 2012. Shortly after that, they issued applications for divorce. Mr. Villiers issuing a writ of divorce in Scotland because that's where the parties had lived throughout the marriage. Wife came down to live in England and issued a petition in England. Husband's writ prevailed and wife allowed her petition to be dismissed. But she then promptly issued an application under this rare beast, Section 27 of the Matrimonial Causes Act 1973. What's that, you ask? It is financial provision orders in case of neglect by a party to a marriage to maintain the other party or children of the family. She spent the following 6 years doggedly pursuing that claim. Husband defended it on all fronts, including jurisdiction, saying that, of course, it should be stayed because of the existence of the Scottish divorce. But last year, in July, the Supreme Court ruled in her favour and she was allowed to pursue her claim. And that's the reference that you see as to the first of the two. That was a Pyrrhic victory for her because earlier this month, 1st to the 5th of March, I think, Justice Mostyn heard her full claim and dismissed it. He did so on the facts, but he was evidently unimpressed that this fairly rare statutory provision, which you may think, looking at the headnote definition on screen, is ostensibly designed to provide support for people who are married, should be used by Mrs. Villiers to pursue a claim for maintenance essentially after the marriage was over. He concluded with the depressing recognition that the result of this terrible litigation, as he called it, is that the parties now are financially ruined and I suspect psychologically damaged. A rather pessimistic but nevertheless fitting epitaph, I suggest, for many of the litigants who've been involved in the cases that we've been reviewing over the last half hour or so. Well, that's it from me. I hope that that's a helpful summary. I'm going to stop sharing screen now and hand over, I hope, to Gemma.
Thank you, Hamish. I hope you will all agree that was a really interesting and very thorough talk from Hamish. So thank you very much again. In his notes, you will see a summary of Hamish's very impressive CV. I won't go into that now because I'm just acutely aware of the time and I'm pretty sure that some of you will want to ask Hamish some questions about his talk. My area is completely different, so nowhere near that which you've just had explained to you, and my focus in this public law update is in one area only, and that is in respect of sexual abuse fact-finding cases. It's something that I personally am doing a lot of, and it is something where, sadly, despite numerous judgments that are handed down, lessons still are not learnt. I have a handout which is will be accessible, and I'm sure Delphine can help you with regard to how to access that and when. So I will be giving you a whistle-stop tour, effectively, of some of the main judgments that have been coming through over the last year, and one side judgment about what we can do with the court's powers to control evidence when findings are made. So the first case I want to just focus on, and it's giving you the 10 bullet points from Mr. Justice MacDonald, is in the REP Sexual Abuse Finding of Fact Hearing 2019 authority. This authority is a massive judgment, and I have distilled as much of that judgment as I would suggest is relevant for our purposes into this document. But the 10 bullet point highlights, which are really, for us as practitioners, I would suggest is almost like put it on your board at home and use it as a starting point for when you're working through these cases as to the red flags that come up in procedural and investigative errors. So 10 points to look out for are: the investigation of child sexual abuse is a demanding, complex and sensitive task and should be undertaken by those who have received the requisite training. I underline that point because looking at when you have officers who are investigating, are they up to speed with their training? Looking at social workers who are dealing with these cases, have they had ABE guidance in training? Have they even had experience of sexual cases before? Number two, very great professional care is required when dealing with allegations of child sexual abuse, both in the initial phases and at the ABE interview stage. Point three, whatever the nature of the child's presentation and whether the response is immediate, prompt or deferred, the response of professionals and the police must be planned. Children's best interests are rarely served by precipitate action. 4, the primary principles governing and the procedures for the investigation and assessment of alleged child sexual abuse are those set out in the ABE 2011 and Working Together 2018 and must be followed in all cases. 5, any investigation into child sexual abuse that focuses attention on the statements of the child runs the risk of producing a false result if what the child says is unreliable or if the child's primary caretaker is unreliable. 6, all interactions with a child who is making or appears to be making an allegation of child sexual abuse have the potential to influence that child's memory. That is a really important point that I just want you to hold in your minds when I go through the other case law that I'm going to take you through and look at how that specific point really has come up time and time again. Number 7, accounts given by children are susceptible to influence as the result of bias, also known as confirmation bias. We would have heard that phrase time and time again. Preconceived ideas on behalf of the professionals and police. Those speaking to children who have made allegations of sexual abuse must keep an open mind with respect to the allegations and must guard against the development of bias or preconceived ideas. A professional who loses their objectivity ceases by definition to act professionally. Again, that's something that will crop up in some of these other cases that I'm going to refer you to. Number 8, questioning the child should ordinarily be left to a formal ABE interview. If any initial questioning is necessary, it should be limited to eliciting a brief account of what is alleged to have taken place. A more detailed account should not be pursued at that stage. 9, anything that a child says must be recorded in a note and must detail A, the timing, setting and people present, what the child said in the words used by the child, avoiding summaries of the account in the interests of neatness and comprehensibility, and avoiding recordings of the adult's interpretation of what the child said. We have all seen the police logs where there's been an hour's conversation, 40-minute conversation with the child, planning for an ABE, and it's just in a small summary form the questions aren't recorded, the answers aren't recorded, no reference to the demeanour of the child, any of those things that we see in the ABE guidelines. And then finally, the point from this judgment, number 10, overall, the proper methodology is one that combines listening to the child and taking them seriously with an open-minded approach. So bearing in mind this very comprehensive judgment, how has it impacted on the cases that have come through the appeal courts over the last year? So the first case I'd like to just consider with you is Re B and Y 2020. That was a judgment from Lord Justice Baker. B, 9 years old, in April 2019, she has a 90-minute conversation with her teacher where she makes allegations of sexual touching by her father. The conversation takes place, but nothing is written down verbatim, so the teacher doesn't keep a comprehensive note. The police are informed of what's happened, and the police come to the school and have a 40-minute conversation with B, teacher being present, so she's supported. She's then ABE interviewed in May 2019. There was a very informal approach taken to the truth and lies stage, and there were evidence and examples of leading questions throughout that ABE interview. Findings were made, and unsurprisingly, the father in that case decided to appeal, and there are 4 grounds of appeal. They're referred to in my note. I won't take you through all of them. But effectively, the conclusion was that by the appeal courts was that the appeal was to be dismissed. There were breaches of the ABE guidelines, but importantly in this case, and this is where when we're analysing, I suppose, the impact of breaches of ABE guidelines, how far does it damage the narrative, the integrity of the child's story? In this case, the Court of Appeal concluded that although there were some breaches, there was no concern that the child may have been misled by the questions or misled into repeating a false account given at an earlier occasion. The interview was considered by the judge at first instance in the context of all of the other evidence available. So the Court of Appeal said it's within the judge's gift to make those findings. Despite the breaches, the integrity of that child's narrative was not damaged to such an extent that findings were unsafe. Very briefly, there's also the case of T and Derby City Council A, B and X from 2020. That case, in short, involves some breaches of the ABE. During that interview process, the interviewing officer took no heed or paid no heed at all to the intermediary who was stepping in to say, we need to stop this, child is tired. And it got to the stage when they tried to call this child back for a second interview, the child wouldn't even go near the interview room. There was a clear example in this case of confirmation bias on behalf of the interviewing officer. There was inadequate recording of the initial conversation. This was a perfect example of that small summary arising out of a long discussion with a child. So none of the key information recorded that we need as practitioners and the judge needs to consider when looking at how safe the narrative is in the context of all the evidence. So in short, the narrative was not clear. There was no spontaneous and clear allegations being made. The appeal was upheld. And another authority, which is EF, GH and IJ, I really suggest that anyone who is interested or specialises in this area of law, you have a look at this case. It is unique in its facts. And when I read this judgment, I was quite bowled over by what actually went wrong in this case. Not that I'm giving it away about the success or otherwise of the appeal. In this case, it was a judgment by Mr. Justice Kean. There were 3 brothers. Actually, this wasn't an appeal. This was just a judgment that he published because it is so unique. 3 brothers involved, and the context within which the allegations were made by these children is really key. So you've got all of the family moving in with paternal family because some renovation works are being done on their house. During the 3 months that they're living with paternal family, allegations are made by the mother against father of rape back in 2016, so historic. Father slips into a very deep depression, which leads to him attempting suicide on a number of occasions, including, rather unfortunately, an attempt suicide at a family event, which I'm sure the children were quite traumatised by. There was also a contact dispute rumbling along in the background after the parents separated. Again, unsurprising, bearing in mind the rape allegation. Then spring forward, and one day children are watching a BBC programme on paedophiles. I'm not sure whether that was appropriate, bearing in mind their ages, but nevertheless they were watching the programme. After this programme had been watched, an allegation was made, and this triggered a police investigation. And this is where this case is so unique. These three brothers were interviewed 22 times between them. EF was interviewed on 5 occasions. His interviews ranged between 1 hour and 50 minutes to 3 hours 26, so a total of 12 hours of interview. GH was interviewed for on 11 occasions, ranging from 10 minutes to 2 hours 54. He had a total of 16 hours of interview. And IJ had 6 interviews, ranging from 30 minutes to 1 hour 53, 9 hours of interview. These boys, between them, during that interview process, made the most serious sexual allegations. And those were considered by the court. There was a medical examination undertaken by Dr. David Glasgow, a name that I'm sure we are all familiar with. And in his report, interestingly, he flagged up his concern over the interview process being very detrimental to the children's welfare, and also the damage of that on the integrity of the children's accounts. Anyway, the officer in charge was named and shamed in this judgment quite spectacularly. So again, for that alone, it's worth the read. There was no consideration of ABE guidance, and the judgment is so harsh, you have this image in your mind of the officer in charge taking the ABE guidelines, marching into a car park and setting fire to them. So little regard was given. There was no planning or preparation of these children prior to any interview. The interviews were excessively lengthy, and they were also instructed interviews. At one point, the officer in charge in her evidence made the comment, "The boys knew what I wanted." So she had an agenda when she was interviewing, confirmation bias at its most extreme. So no open mind, no free narrative, victim-led completely. And the investigation was described as being utterly incompetent. So I think that's putting it mildly. So Kian comes up with a decision, unsurprisingly, couldn't even begin to be satisfied on the balance of probabilities that the allegations of physical and sexual abuse are proved. So a very worthwhile read, that judgment. Bringing forward to a more recent judgment from this year, this is again a very interesting case. Because not just the investigative process, but actually the way the local authority dealt with this. And it's one of those ones where you'll read it, and if you're like me, you scratch your head and think, what were they thinking? So this case is JB, a child, sexual abuse allegations 2021. It's a judgment by Lord Justice Baker. Now, Mum had her first child, who we are referring to as E, removed in 2013. E would have been 4.5 when she was removed, and she was placed with special guardians. Now, contact between Mum and E sort of trickled along rather, I suppose, disastrously until about 2016, when all contact stopped. In 2017, E's behaviour becomes completely dysregulated and off the scale. She's sexually abusing another child who's living with her. She is abusing a dog in the family pet. She is urinating around the house. Her behaviour is really disturbed and dysregulated. We get to the 1st of December 2017, and E makes her first allegation that she has been sexually abused by her mother back when she was in her care. So this is historical abuse, and hold in your mind the fact that this child was 4.5 when she left mother's care. She makes allegations on the 2nd, 4th and 5th of December. These are eventually reported to the police. There's no record of this. There's no record of anything until about January 2018. So we don't have any contemporaneous note of what the referrals contained, or indeed what the special guardian was informing professionals of. We get to the 8th of December and 2017, and there's the police and the social worker talk to E for over an hour, and they just set up an ABE interview, which takes place on the 22nd of December. Between the 8th and the 22nd, there are numerous conversations from the well-meaning special guardian with the child. She's encouraged to make notes. The notes are kept in the special box. There's a special one-to-one time. The usual things that we can see from well-meaning carers, well-meaning foster carers that take place. So we spring forward again to March 2018, 18, and E starts making allegations now about maternal uncle. Those allegations are subject to a further ABE interview. The police are very concerned about what's been happening. They take no further action. Everything is left. E remains with special guardians. Nothing happens. No idea if any therapeutic support was put in place, but special guardians muddling along with E. Mum, let's have a look at her now. 2019, she's pregnant, and the local authority, their interest is piqued. So they immediately, as soon as child is born, initiate proceedings. And guess what? And this is the scratch your head moment in my view. They decide that in amongst everything they're going to consider, they are going to resurrect the allegations that E made in 2017 and pursue them at fact-finding. Findings were made, so there was an appeal. Lord Justice Baker considered that appeal, and he summarises there are numerous breaches of the ABE guidelines. The note of the initial meeting was insufficient. It's a surprise, again, a recurring theme through all of these judgments that I'm referring you to. No rapport phase was given. There was no detailed exploration of truth and lies. There was some suggestion that perhaps truth and lies had been done off camera in another room. No idea what the officer in charge was thinking when that happened. And the officer read the notes out that were made, you know, the special notes kept in the special box, read those out and asked direct questions about those notes. There was no free narrative. Limited attention was given by the judge at first instance to the age of the child. Remember, I made the point that 4.5 years old, so the abuse, she would have been 3 to 4.5 maximum when this abuse was alleged to have taken place. Between the initial conversation, the well-meaning special guardian, what was the impact, what was the influence of her well-meaning wraparound trying to protect this child and support her, but nevertheless, what impact did that have on the narrative of this child? Any suggestion of a protective scaffold around the child's allegations was just non-existent. So again, unsurprisingly, the appeal was allowed. So you can see, are lessons learned? No, they're not. What can we do with these things that are coming up time and time again? Well, some cases that I've been involved in recently, the judge that's heard the cases has done something along the lines of writing a small judgment, sending it to Dorset Police Force and suggesting that the whole of the police force needs to be retrained, and that the officer in charge of this particular investigation shouldn't be let near any children again until such times as he specifically has had training. So that's just an idea for when we see significant breaches by police. The final question, which I wanted to throw in as an aside, was about the control of documents. And I will only spend a couple of minutes on this because I know that perhaps some of you have some questions for Hamish that he needs to answer, and I want there to be time for that. So this is, I've never thought of doing this. Maybe you have, but it's not something that I've thought of before. But having read this judgment, I think it's a really useful tool for us to consider and to hold. So this judgment is Our Children Control of Court Documents 2021. It's a Lord Justice Peter Jackson judgment, and it's a good judgment to read. So the case involved, or this particular issue involved R. He was the adult brother of 2 sisters who were the subject of care proceedings. R was the intervener. Now, R was described in the judgment at first instance as a predatory paedophile who had raped one of his sisters. This is a very, very deeply troubled and deeply unpleasant individual. He was serving a 21-year prison sentence for having pleaded guilty to raping his own 3-year-old daughter. And not only did he rape his daughter, he took photographs and footage of that sexual assault and distributed those images. It's probably the vilest type of human walking the face of this planet. During the proceedings, while he's in prison, the only access he has to the documents within the proceedings is via his legal team when they have conferences. He's not allowed to have any physical documents in prison with him. Perhaps we can understand that. It's not unusual, is it, for papers to be held in our solicitors' offices, and when we have conferences, information to be disseminated to our clients. It went a bit further than that, though, in this case. The judge made a decision, in this case, that R was not allowed to have a copy of the submissions written on his behalf. He was not allowed a copy or to see the submissions made on behalf of the other people. He was not allowed to be told the full content of the judgment. He was given a summary only. and was not allowed to have any of this in paper form whilst he's in prison, are appealed, saying it was effectively his right to these documents. He's an intervener. He should have full control over those papers. This was considered by the Court of Appeal after the judge made that order that he was to have nothing. And the summary of this is that the court has the power to control and withhold documentation from parties where that is necessary. A word that we hear, I think, on a number of applications, necessary for whatever we're asking for. There will be rare cases where the possession of documents may amount to more than an interference with privacy. In this case, it was said that if R had the documents in his possession, he would have more than likely used them for his own sexual gratification. That was held by the court to be equivalent to degrading treatment within the meaning of Article 3 of the Human Rights Act. So the court has the power to withhold anything it wants from parties, from interveners, where it is strictly necessary. And I'm sure a number of us have had cases where there are very serious findings have been made against either parties or interveners. And we've wondered whether or not only a redacted form, but perhaps a severely redacted, i.e. no detail of allegations, no detail of the exact findings, but a very, very bland summary is provided by the judge, given and passed on to the intervener or that party by way of an oral summary. So one to just hold in your arsenal of weapons for any cases that you are dealing with that involve allegations of sexual abuse. As I say, the handout that I've produced has got so much more detail in there on all of these cases that I've discussed, and that is available to all of you. And that is it from me. So I hope that was slightly interesting and slightly useful. And what I can say is that if you do enjoy our seminars, you will be very pleased to know that we have another one coming up on the 29th of April. Yes, that's right, 29th of April. I had to think what month we were in then. So thank you so much for listening to both of us. And I really hope you have some questions for Hamish, not me. Yeah, look forward to hearing from you all. Thank you.
Thank you so much, Gemma. A predictably entertaining and informative talk. It's always a difficulty, a challenge to reduce, large numbers of case analysis to a short 25-minute slot. And thank you for doing so succinctly. Questions. Well, I've had a couple of questions. The first has come through on the question panel from Sandra Foster. Thank you very much, Sandra, for your question, which concerned, of course, Diwali, the case involving the delay in selling the family home for 2.5 years and the husband who went off and applied for possession of the property. She asks the question, would the husband have been successful if there was a term of occupational rent in the consent order? Now, I think if I understand that question correct, let me see if I can answer it. First of all, as to would he successfully have been able to win occupational rent, the answer is yes, because the court would have addressed that question by reference to the terms of the consent order. If the order required wife to pay an occupational rent and she failed to do so, then of course she'd be liable to the husband for the arrears, but by virtue of what she'd agreed to and the court had ratified in the consent order itself. But her failure to pay rent, would that allow him to seek possession of the property? Well, the answer is not unless the terms of the order permitted that interpretation, because we come back to the point that it's always the order itself which gives rise to the regulation of the parties' relationships between the two of them afterwards. I've had another question, this one concerning the development of law on applying to vary final orders. You remember the EB case from Mr. Justice Mostyn. What is the prospect, says the question, of there being a development in the law on applying to vary final orders? And I think my answer to that is that there are some prospects. In practical terms, it seems to me in the future, the court's likely to face applications from those who are faced with having to pay large lump sums or maintenance, and who say they can't afford to do so, because the original order, as formulated, has become incapable of being met by dint of the consequences of the perfect storm. And I think that despite Mr. Justice Mostyn's emphatic decision in CB&EB that the traditional grounds are the only grounds, then it seems to me that some applicants may try and use Mr. Justice Knowles's rather more flexible interpretation, and to see if there's some room in the law for coming back to apply to vary on slightly broader grounds than that. Well, I'm pleased to say, Gemma, those were the only 2 questions that I had. I look at the time and see we are at 11:58. Have you got any questions that you were asked, and if so, do you want to deal with them now?
I don't know. I think I was just so thorough in my presentation that nobody's got any questions. But there was one thing that did spring to mind, actually, which I'm just going to, just in case anybody ever comes up against this. I was asked at a previous talk about, in respect to private law, when police investigations are dragging along, whether there's anything the court can do to help chivvy things along, or whether there's any powers that the court has over those investigations. And there is an authority which is H, and I don't have the, it's 2018 EWFC 61, and it's paragraph 22 of that judgment, which answers that specific question. And effectively, the court has zero power to railroad the police force into either hurrying up their investigation, providing anything that they to us. For example, if they've got a forensic analysis going on of various items seized, the court can't say, well, actually, we'll take hold of those and we'll get them analysed a lot quicker than you. So if it's going to take 9 months for that to come, it's going to take 9 months. So when you're in that really frustrating stage of you're trying to get ready for a fact-finding hearing, and there's a number of pieces of outstanding investigations or analysis of items, or police is taking their time with interviews, there's nothing we can do to speed that up. So if anybody comes up with that as an issue in your case, you know the answer now. So yeah, but that's it.
Thanks, Gemma. As Gemma indicated a little earlier in the talk, handouts for both of our talks are going to be available a little later today, as I suspect our recordings, webinars of our talks, which will include, of course, the telephone in my office ringing twice during the course of my talk, for which I have to apologise in retrospect. As Gemma indicated, the next brunch seminar will be on the 29th of April. The list of potential speakers at 3PB is, of course, long and impressive, and we're currently selecting which is the most appropriate fit, so please watch this space. For the meantime, at midday, thank you so much for joining us, and we wish you a very good day and a very good weekend. Bye-bye now.
Thank you, bye.